Uduezue and Bexley, London Borough Council, and Zaman and London Borough of Waltham.
Mr. Grundy, just before you resume, Mr. Burton, thank you very much for the amended grounds of appeal. As I understand it, there's no objection to those. And I see we've also been...
I was going to introduce the three.
Yes.
I was going to introduce the amended grounds of appeal and say there's no objection to them as a means of saving time. You have three authorities. Two have been produced by my learned friend on behalf of Bexley Heath, Mr. Calzavada. They are Haddock and Churston Golf Club, 2019 EWCA Civ 544, decision of the Court of Appeal of Patton, Lord Justice Patton, Baker, and Mr. Justice Newey, as he then was. And then the possibly better known Tan Fern Limited and Cameron MacDonald and another, a practice note from the One Weekly Law Report 2000 at page 1311. You'll see who the judges are on that. And then thirdly, a decision that you were involved in, my lord, called Broderick. There's a real temptation to say free Broderick. Broderick v Bromley, London Borough Council.
Yes.
Which I will be taking to you to in due course. I am hoping to finish by noon. I've spoken to my learned friend, Mr. Calzavara, about that. He thinks he will be a little bit more than an hour, so he would be over into the afternoon, but that would leave half an hour for replies for each of my learned friends on behalf of the appellants.
That sounds fine.
What I am hoping to do, so that you understand the timescales, is do a summary of where I'm going, of the trajectory, deal with ground one for 50 minutes, ground two for 30 minutes, and then explain the evolution of the claimant, of the appellant's case in this case, and how it has been somewhat of a moving feast, making it particularly difficult for the respondent to respond at any particular time. So in relation to the summary, my lords, my lady, ground one, a little Roman 1, it's a bit like the 1996 Housing Act section 193, isn't it? Alphabeti spaghetti. Anyway, the time element of the allocation policy is irrational. The summary of the response to that is, following Broderick and Alib Kiet, or the Adam decision in Alib Kiet, there is no requirement of the time element. Ground A, 1A, little 2, failure of the policy to apply out of borough duty, i.e. as close as possible. To a certain extent, that falls on when you look at what the duty actually is, which we did yesterday afternoon. But in any event, when you read the policies together, you'll see that, in fact, the authority are trying to secure accommodation as close as possible in the procurement policy or the acquisitions policy. And then when you look at the allocation policy, you'll see that there is no, as my learned friend calls them, holding mechanism in that policy. Effectively, people are allocated the property that is closest, even if they have been designated as somebody to whom a Zone C offer could be made. Ground 1B, failure to consider closer properties. Failure to consider affordability of closer two-bedroom accommodation. The response to that is that on the day on which the allocation was made, there were no closer two-bed properties. So if we are right that there is no time element, then that necessarily falls. I think that was conceded. And then in relation to ground 1C, procurement and evidence of compliance with the policy, the response into that is there is evidence. What more evidence would be sufficient in any circumstances? And what the appellant currently say, I think in their amended skeleton argument, is they want details of the providers that we engaged with. So once they have the details of the providers, well, don't they want them to know whether they were working on the day on which that allocation was made? And how hard were they working? Were they working so hard that it was reasonably practicable? Or were they just working at a sort of a slower pace that didn't make it reasonably practicable? It was also, the response to that is that it's also based on a logical fallacy. Mr. Bernardini, apologise. Bernardini?
Bernardi.
Pardon?
It was Derek Bernardi.
Derek Bernardi says it is inconceivable that there wasn't a closer property to the London Borough of Waltham Forest than Stoke-on-Trent. Therefore, you didn't use all reasonably practical efforts to find it. There is a needle in that haystack. You didn't find it. Therefore, you didn't take all reasonable practical steps to find it. So it's a logical fallacy. So that's the response to the 4 elements now of ground 1. Ground 2, in relation to affordability, we will distinguish Paley and show that notwithstanding that Miss Zaman was represented and the minded to letter raised the issue of transport back to London, and at the time that the minded to letter was responded to, and even before the minded to letter was issued, Miss Zaman's legal representatives had the affordability assessment and didn't say, hang on a minute, you haven't accounted for any transport. In any event, there was £130 per week surplus. So that's the trajectory. Going then on back to the beginning and dealing with ground 1. To a certain extent, I'm rolling all of the elements of ground 1 together, but I recognise that there are different aspects to it. Yesterday, I was asked by my Lord Newey, would it have been lawful for a local authority to allocate people to Penzance if that was part of a policy? And I said, yes, I think it would. There's a nuance to that, of course. That wouldn't satisfy the in-borough requirement. That's the first point. Secondly, it wouldn't satisfy the requirement to find accommodation as close as possible to where the person was previously living. So my glib answer requires some refinement.
We're back to the same house though, aren't we? Which we've been going round, which is Penzance or is Stoke-on-Trent as close as can be achieved reasonably?
Reasonably practically. Or no, sorry, not reasonably practically. No.
Yeah.
To try to.
Yeah, or not. And if, in fact, one only looks in Penzance, can one show that one has satisfied that duty? That's the question.
Absolutely, that's the nuance. And the point about the change in the code that I took you to is that what it really does is says, even if there was somewhere closer that was suitable, that was in zone, that was in your, not in your borough requirements, that doesn't automatically become, the one you offered which is further away is not automatically unsuitable.
Where'd you get that from?
From the change in the Code of Guidance, my lady. So if you look at divider 6 in the bundle of authority, I hoped I'd established this yesterday. It's slightly worrying to hear.
Sorry if we've forgotten.
Paragraph 17.49 of the 2020 June iteration of the 2018 Code, at page 49, says, repeats what the supplemental 2012 guidance said that was considered in the Zolomezo, but adds the caveat that the fact that there was something closer does not automatically make the further away accommodation unsuitable if the accommodation is offered in accordance with a published policy which provides for fair and reasonable allocation of accommodation that is or may become available.
So it's your reliance, as you said yesterday, on that final sentence?
Yes. Well, what I say is that takes away the it must be as close as possible. That takes away the if there was anything closer when the allocation was made, that makes what was offered unsuitable. The case of Salah was decided on the basis of the code as drafted and considered in Nzolomezo, so before that change was made. So the issue in Salah was the local authority required at the date of review to look at whether or not there was closer accommodation having already offered somebody and discharged its duty by an offer of accommodation, when you come to the review, you have to reconsider all matters. In Salah, the local authority didn't look to see whether or not there was something closer than the offered accommodation, and that failure resulted in the decision in Salah being overturned. So we looked yesterday through the acquisition policy, and we saw that there is a duty to acquire, the acquisition policy complies with the law as is conceded and says expressly that the borough will try to acquire property as close to the borough as possible. My learned junior very kindly pointed out that paragraph 5.4 on the acquisitions policy at page 13 in the supplemental bundle repeats the instruction that suppliers are requested to procure as many properties as possible in borough, to procure properties in nearby locations wherever possible, and to procure properties as close to the borough as possible when considering other areas.
I'm sorry, I'm behind on that, and I know we're recapping, but it's very important. So we're at the page
13, my lady,
13.
I apologise, I'm going quickly because...
No, I know, why you're going quickly.
So my learned friend took more than double the time that we'd allocated to ourselves yesterday. And there are 37 pages of written material. Pardon?
He did do the heavy lifting on the law.
Well, there's some disputes about what he said about the law, so that's going to have to be dealt with, my lady.
So anyway, you say, and I think Mr. Burton accepts, there's nothing wrong with the acquisitions policy.
Absolutely. Then we turn to the offer policy, or the allocation policy. It's my submission that the three zones correspond to the duty to find or to offer where reasonably practicable accommodation in borough. Zone B is the as close as possible to the borough so that ties will not be broken. And then zone C is if neither of those duties can be met. Sorry, if neither of those requirements can be met. Paragraph 3.12 of the allocations code, in my submission, is important.
This is page 8, isn't it?
It's on page 8. And it says the impact of these and any, so it's referring to the basis upon which assessment of need is made, set out in paragraph 3.1 of the code. And 3.12 says, the impact of these and any other relevant circumstances will be considered both individually and cumulatively. Households that have a relatively low level of need when considering the above circumstances are more likely to be offered accommodations in zone B and C. However, even if a household is considered to have a lower level of need than other applicants to be in or close to the borough, they will be offered available units in zone A or zone B if these units are not required by higher priority households. So my learned friend has referred to a holding, holding some back. And in Nicola and in Alib Kiet, Baroness Hale and Lord Justice Lewison respectively said, yes, you can do that. They didn't say you have to do that. They say you can hold back in the event of anticipated need. Now, anticipated need in these circumstances is very, very difficult. On any day, any number of homeless applicants may make a homelessness application, and however many might be found to owe the duty and in due course have the main duty to be made an offer. The London Borough of Waltham Forest does not operate a holding property back system. if there had been suitable accommodation for Miss Zaman in zones B or A on the date on which the offer was made, under the policy here, they would have been offered to her.
But they have to be suitable, and the
They have, sorry, yes.
and the issue is that she hasn't got enough money.
So they'd have to, yeah.
So no.
Well, hang on. Subject to affordability. So suitability has a number of aspects. And what the local authorities say in this case, and it's clear from the review decision and clear from Miss Bart's witness statement, is given you are subject to the benefit cap, and given that the local housing allowance is this in Greater London, it would have been impossible for us to find you somewhere in Zone 2 that was suitable. So suitability is not just about location. Suitability, if somebody cannot in the long term afford the accommodation, it is also unsuitable. So, my lady, you're absolutely right that in practice, it is very unlikely that the local authority would have found somewhere in zones A or B that would have been affordably suitable, suitable by reason of affordability for Miss Zaman.
And so the real battleground here is in relation to the ripples, if I put it that way, in Ground C. And it's whether your policy, etc., and the way that it has been exercised and the evidence of the way it's been exercised is sufficient to show that there was anywhere that you should have been looking at between Stoke and Trent and the barrier, the border of Zone B.
My lady, yes. That's right. It seems to me that that's what it comes down to.
That's the battleground.
That's the battleground, yes. And it's right, if you look at the review decision letter, you'll see that Miss Zaman was effectively told that quite early in the process. So she wasn't told, the review decision letter sets out in some detail the history. So I don't know to what extent you're familiar with the legislation, but it was also amended by the introduction of something called the Homelessness Prevention Act. So local authorities now have a preliminary duty to try and maintain people in their housing when there's a risk of them being made homeless, and when they are made homeless, they don't carry out all of the investigations that they carry out to give rise to the Section 193 duty. They have something called the relief duty. And part of that is the preparation of a personal housing plan, often referred to as a PHP. So if you turn to paragraph 18 in the review decision letter, 135 in the core bundle, paragraph 18, it's at the top, it's the second paragraph down. On the 16th of June 2021 at 09:24 hours, Miss Grant responded to your email reminding you from the outset of your application you were advised, so she hasn't only just been advised on June, but from the outset, you may not be made an offer of a council house. Miss Grant explained that this council will be discharging their duty towards you by making you an offer of a PRSO accommodation, and that this accommodation may be outside London and may not be a house. You were advised to be active with seeking out alternative accommodation. So the local authority they were realistic about this case. So if, I now turn really to, in my submission, other than the evidence of compliance, I will deal now with evidence of compliance of the procurement duty. In order to deal with that, it's probably sensible if I go first to Abdi Kadir, in respect to which I might need some help from my learned junior. Abdi Kadir is at divider 31 in your bundle, my lord, my lady. and I'm going to start at the end of Abdi Kadir on page 638. Sometimes not a very good place to start. Anyway, you'll see paragraph, this is the judgment of Lord Justice Lewison. In my submission, a Lord Justice with a great deal of experience and expertise in relation to these housing cases. He says at paragraph 60, for these reasons, I have come to the reluctant conclusion that this ground of appeal succeeds. So it wasn't a ringing endorsement. Why was he reluctant? He was reluctant because at paragraph 59, counsel for the respondent, the Ealing London Borough Council, had reminded him not to over-judicialise welfare services. What was it that the London Borough of Ealing had not done in the process that it should have done that gave rise to Lord Justice Lewison reluctantly allowing the ground of appeal? The London Borough of Ealing had a policy. In that policy, perhaps foolishly, they said that when they made an offer, on a date when they were considering making an offer, they would check available websites on a daily basis. So that is, if you read paragraph 57, my lords, my lady, you'll see that that part of the acquisition policy is set out in the penultimate sentence of that paragraph.
And it's at 55 as well.
And at 55. Sorry, apologise, my lady.
And it's at 55 as well. I was just helping you. There's a reference to the daily basis for a new supply in 55.
Yes, I'm very grateful for any help, my lady. There was simply no evidence at all. Nothing. Notwithstanding that there was no evidence that the London Borough of Ealing had complied with his own policy, Lord Justice Lewison was nonetheless reluctant to allow the ground of appeal. What Lord Justice Lewison says is that the London Borough of Ealing must have considered in the adoption of its policy that in order to take all reasonably practicable steps to secure property in borough, it must do this daily search. So that's at paragraph 54, my lord, my ladies, at the bottom of page 637. What steps are reasonable steps to take in order to fill that duty is a question of judgment for the housing authority. But its decision on that question is, in my judgment, to be found in the terms of its policy, which can be taken to be Ealing's considered judgment on the question. So my learned junior reminds me of something that is relevant in this case. This offer was not a private rented sector offer. Notwithstanding that it wasn't a private rented sector offer, the policy nonetheless said we will look on the websites on a daily basis.
To encompass potential PRSOs.
Absolutely. My understanding is that the landlord under this case was intended to be the council itself or a housing association. So in effect, I don't know if it was Miss or Mr, I apologise, Mr Abdi Kadir was getting something that might be regarded as preferable to a private rented sector offer. So if I can show you what the evidence was before the court, at paragraph 15 in the judgment, you'll see that paragraph 15, I apologise to her, Miss Abdi Kadir requested a review of that decision. In preparation for that review, the reviewing officer made inquiries about what accommodation was available at the date of the offer. The response recorded in a file note of the 24th of September 2020 was that 10 Whitehorn Avenue was the only 4-bedroom accommodation available on that date. Apparently the decision was upheld, but Miss Abdi Kadir successfully appealed against the County Court. Ealing therefore undertook a fresh review, and it is that review that is the issue on this appeal. So there was no evidence that they'd done their daily search. And it was, as I understand it, an anonymous file note, so unattributed. So what is the evidence in the current case? Well, the evidence in the current case is set out in the minded to letter, in the review decision letter, and in Miss Bart's witness statement. The review decision letter sets out the accommodation that was available to be allocated on the 22nd of July 2022. And I think that's paragraph 141. 143, I apologise. Starting on page 160. The property that was available is set out at page 161 on the 22nd of July, and then on the 28th of September, further down the page at 161 over to 162.
I mean, strictly, the position at the date of the review
is irrelevant for doesn't matter for these purposes, but it is evidence that the London Borough of Waltham Forest was looking and applying its allocation policy because there were properties available in Zone B. Now you'll see that all of the properties except for the offered property under the first bold heading, the properties that were available at the time the offer of accommodation to you on the 22nd of July 21 were as follows, are all referred to as temporary accommodation. So they are not PRSOs. They might be from the private rented sector, but they were not being used by the council to cause the duty to cease. They were being used in performance of the duty.
So just so I understand that, so we're looking at the 22nd of July list.
Yes.
Absolutely strictly, the fifth bullet point is not described as temporary.
No, it isn't. I apologise. And yes, you're right. And that's important because if you look at the ones for the September 2021, you'll see that some are referred to as temporary accommodation. And if you look over the page at 162, there are two referred to as a property in the private sector. The top bullet point and the third bullet point.
So those we assume would have been PRSOs.
Those would have been PRSOs, yes. Interestingly, on the date of the drafting of the review letter, there were no properties available. On Mr. Bernardi's case, or his logical fallacy, that's evidence that they weren't performing their duty to find enough accommodation. So that's the first pillar we have in the evidence of complying with their allocation policy to secure accommodation. The second pillar that we have is the Freedom of Information Act response. Now, that Freedom of Information request was made by Mr. Bernardini at Camden Law Centre on behalf of Mr. Mann. And the responses to the questions he asked, they're not responses that the council has contrived or that they are direct responses to the questions as he put them. My learned friend said, oh look, 50% of the properties come from Stoke-on-Trent. Well, that's simply wrong. They were asked to provide information over 5 years. They only have information over 3 years. And they dealt with the 3 financial years preceding 2021, preceding March 2021. So in Zone A, you can see...
Sorry, which page are you at?
I apologise, I didn't tell you. I'm in the supplemental bundle at page 171. I'm really sorry. It's the pre-penultimate page.
Yes.
So, for these purposes, if we look at the responses to question 3 and 4, April 18 to March 19, 140 in Zone C and 4 in Stoke-on-Trent. April 19 to March 20, 247 in Zone C, 70 of which are in Stoke-on-Trent. And April 20 to March 21, of 116, 51 are in Stoke-on-Trent. I accept that the percentage of Zone C property in Stoke-on-Trent is increasing. But it coincides with the introduction of the benefits cap and the cost of living crisis.
Does it? I'm following the point about the benefits cap, but the cost of living crisis hadn't
March
taken hold
21?
by March 21, had it?
But that's I rely on this as evidence that the borough is looking for accommodation in Zone C. And it isn't just looking in Stoke-on-Trent. Because if it was looking just in Stoke-on-Trent, it would only be securing accommodation in Stoke-on-Trent. And Mr. Bernardi's position, I think, as expressed in the original grounds, was you have an unwritten policy of only moving people to Stoke-on-Trent. And when we look at the response, part of the responses in the dialogue between the council and Mr. Bernardi, that part of it is misconstrued or misinterpreted or misrepresented by my learned friend because they were responding to that allegation. You are only looking in Stoke-on-Trent. So, in effect, of course, it's not a response to the questions he poses, but it was a response to the question that was being asked at the time. So that's the second pillar in the evidence that Waltham Forest was complying with its allocation policy, with its acquisitions policy. The third is paragraph 13 of Miss Bart's witness statement at page 109 in the supplemental bundle. It doesn't just say, as my learned friend has represented, that they're only looking in Zone B. What it says at paragraph 13 in the last clause of the sentence is, Miss Hussain, i.e. the manager of the procurement team, confirmed that when the team go out to procure properties, they seek to procure in all locations, including the Zone B locations.
I mean, it certainly doesn't in terms say that they are looking for the properties that are closest. Zone C.
It doesn't say that, no. So that then brings us to what evidence would my learned friend accept as sufficient? Yeah, I'll come to that. Was it in the supplemental stuff? No, we have to put the details of the 14, isn't it? No, 4, was it? So if you look at the supplemental skeleton argument, my lord and lady.
Meaning Mr. Burton's.
Pardon?
Meaning Mr. Burton's.
Mr. Burton's yeah, well, no one else has done a supplemental skeleton.
Well, we hadn't realised he had.
No. Paragraph 14b at page 8. Sentence starting, however, there is no information, even in general terms, about which suppliers and landlords the respondents work with, how these are selected, or what active steps the respondent takes via its suppliers or its suppliers take to procure accommodation. The system of procurement is opaque to say the least. So let's say that information was provided. What would the question then be? Well, when did they look? Where did they look? How did they look? This review decision letter is already over 60 pages long.
What you're up against, in a sense, is common sense. Take the line heading north of London towards the Midlands.
Yes.
You have to go beyond Birmingham to get to Stoke-on-Trent.
You do?
Plainly, Birmingham is closer to London than Stoke-on-Trent is, whether you look at it as the crow flies or
yes.
whether you look at it in terms of transport links.
Right.
And common sense suggests that it would be possible to find accommodation in Birmingham that would be within affordability criteria.
My lord, and undoubtedly it is found in Birmingham. The question is, on the day on which the allocation was made to Miss Zaman, what was the closest accommodation that was available? Now, Mr. Bernardini's case, and I think you, in effect, the common sense argument is it is inconceivable that there wasn't something closer. So let's say we found something in Birmingham. It is inconceivable that there wasn't something in Northampton. Find something in Northampton. It is inconceivable that there wasn't something in Luton.
I mean, can I turn it round? We see, as you've shown us from the FOI request, that a substantial proportion of Zone C allocations is at Stoke.
Yes.
On the face of it, you think, how can that be? How can that, in all those cases, be the closest to London? If it isn't, then it isn't that the policy of procurement is wrong, but the operation of the policy must be wrong.
My lord, what we need to get back to, what was the duty in relation to as close as possible to the borough? And that was the second part of the hierarchy, if you remember. The first part was within borough, and then it was as close as possible, not to the borough, but to where the previous accommodation was.
Which is in the borough.
which is that Zone B. Yeah? And the purpose of that was to maintain ties. There isn't a duty that says it must otherwise be as close as possible to the borough, other than that one in relation to maintaining ties. What is being argued here is an absence of something is proof that reasonable efforts were not made to find closer accommodation. And that's the logical fallacy that I tried to illustrate with the needle in the haystack.
I mean, I quite follow that if, as you were rather suggesting last night and are sort of suggesting now, it isn't incumbent on the local authority when it gets outside Zone B to try to find things that are as close as possible to the borough. Fine. But if you're wrong about that, common sense suggests that something's gone wrong because all these people are being put in Stoke, and there surely must be affordable things closer than Stoke.
There may very well be closer things than Stoke, but that's the question is in this case is on the date that this was allocated to Miss Zaman, was there anything closer that was available?
And a question is that the question? I mean, I quite follow. Mr. Burton would have an easy task if, looking at the list, one could say there was something available in wherever that was closer, and you didn't choose that.
Yes.
His task is made more difficult by the fact that that is not the case. But supposing that the fact that there was nothing available is or may be attributable to a failure to implement the policy of procurement, well, that might be enough for him, mightn't it?
Well, I would submit it's not enough because the evidence I've taken you to show that they are looking in all locations. They are looking in Zone C and not just in Stoke-on-Trent.
Yes, but you haven't got. The only evidence that there is activity in looking in Zone C, other than in Stoke-on-Trent, are those FOI figures.
Well, no, it's Miss Bart's statement they look in all locations. So the procurement officer says we look in all locations. And it's the outside, I accept that the other accommodation that was available on the dates was in Zone A and Zone B. I accept that. But in Uduezue, Baroness Hale said, how does the local authority evidence its compliance with its duty? It has a policy. Well, what's now being expected is that you go beyond having a policy and that on a daily basis you prove compliance with your policy. So a sort of presumption of regularity doesn't exist for local authorities performing their homelessness duty because it is inconceivable. But the inconceivability doesn't mean that the local authority hasn't taken reasonable steps or hasn't tried to.
I mean, it may be slightly different from that. Maybe there is no obvious inherent. Maybe where there is no obvious inherent unlikelihood. I'll put it differently. Maybe where there is no obvious inherent likelihood of something having gone wrong, the presumption of regularity works.
Yes.
The difficulty here is that common sense suggests that something has gone wrong.
So, but the problem with that is, my lord, that in those circumstances, if anybody is offered a property in Stoke-on-Trent, that indicates that you haven't complied with your policy, even if there was compliance with the policy and the only available accommodation on that date was in Stoke-on-Trent. So it's all swans are white, because I've only ever seen white swans. They're not. They're maybe black swans.
But it could be that where, on the face of it, it looks as though something's gone wrong as a matter of inherent likelihood, it's incumbent on the local authority to evidence compliance with its policy better.
It may be. I mean, it seems to me it would depend upon the height of the level of the duty. And the duty in this case is not that it's reasonably practicable, but it's to try to. and even if there was something closer that was available, the local authority wouldn't be in breach of that duty if the further away accommodation was allocated in accordance with an allocation scheme. But I am very anxious that the implication is, unless you establish or prove that there are people on the ground asking in other areas closer than Stoke-on-Trent, we're going to presume that you're not doing that. In relation to Miss Bart's witness statement of paragraph 13, you'll see that what she's responding to, and that's, my lords, my lady, at page 109 in the supplemental bundle. And it says it's under a heading, in response to ground 1, subsection 3A, 3B and 3C. And you'll see under paragraph 12, she sets out the basis upon which she asked the question. In answering why the appellant was not provided with a Zone A property or even a Zone B property, this was because none was available, and in any event, the information financial analysis on file showed that the appellant would have been unable to afford the rent. If you look at how those grounds were put below, because we've now got to the 4th iteration, I think, of Miss Zaman's grounds. They were originally put by Mr. Bernardini, and interestingly, he was the person who was making the request. He was the person making the representations on review, so presumably he knew what was an issue before council got hold of it. They start in the core bundle at page 76, my lords, my lady. And I'd ask you just to look at ground 1, which starts at 76, and then paragraph 4. The respondent's own private rented sector offer policy at paragraph 3.2 provides that all PRSOs are zoned. We know the zones. 5. Having determined that there were no properties available in Zone A, the respondents in effect leapfrogged Zone B and made a PRSO offer in Zone C. They have provided no evidence that any effort was made to secure accommodation in Zone B. The grounds were amended by my learned friend's junior, Miss McGibbon. And you'll see there at page 82. And I accept that ground 3C, ground 1 in paragraph 3C, makes the point that the respondent fails to consider whether accommodation might be available at a location in Zone C which is closer to its own district than the property. That's a question about allocation rather than procurement, it seems to me. But the ground about overleaping Zone B is still there, proceeding. So, I mean, this has been the difficulty responding to Miss Zaman's grounds, is that they just move. I'm better when I move. That's Butch Cassidy and Snow. Anyway.
I mean, you obviously have limited time, so it's probably not worth taking time on this. But in a sense, we go back to the review decision. And I think Mr. Bernardi had, pre the review decision, raised questions along these lines, hadn't he? And if so, I might have thought that the review decision would provide better evidence of compliance with the procurement policy.
So the review, the request, last lot of representations on review are at page 166 in the supplemental bundle.
In the supplemental.
So that's about 5 pages from the end of the supplemental bundle. Now, at this point, the arguments have got quite honed because there's been a minded to letter, and Mr. Bernardi is clearly responding to the minded to letter because he says, subject submissions in response to the minded to letter, page 166. Under the heading distance of property from local area, he says he deals with the Mears report that the London Borough of Waltham Forest had commissioned about a reasonable period of time. Additionally, the minded to letter, I'm on page 167, my lady.
I'm actually looking, I'm just double checking something you said. It's okay, I'm checking.
My lady, yes. Additionally, the minded to letter sets out the properties that were available at the date of the initial offer and the date of the minded to letter. All of the properties listed are located within Greater London. However, the Council's acquisitions policy provides that where the Council is unable to procure sufficient numbers of property in borough, it will address this shortfall by acquiring units in nearby locations. And then he sets out Zone B. It appears that the Council did not search for, or alternatively in breach of its own policy, failed to acquire. So here we go, the logical fallacy. If you don't acquire, you're in breach of your policy.
But you can be.
You could be, but what Mr. Bernardini is saying is, if you fail to acquire, that proves you breached your policy. Right? And he goes on. Properties in these areas. Rather, having determined that there was no suitable properties available in Zone A, it fetters its discretion to offer a closer property, instead secured a property in Zone C in Staffordshire. The Council has not provided any reasonable justification for failing at least to make an offer in Zone B. Well, it has. It said you couldn't afford those.
But the difficulty is he then goes on in the next two paragraphs to talk about Zone C.
He does.
And that might then have prompted the review decision to say, well, look.
But if you read those two paragraphs, he doesn't say you haven't. He says you have. It appears that you have a policy, an unlawful policy, of sending everybody who's not in Zone A or B to Stoke.
We submit it as unlikely in the extreme that on at least 121 occasions the Council was unable to secure a property closer to the borough.
Absolutely.
And that might have triggered the review decision saying, well, no, there was a good reason for that.
Yes.
And it doesn't.
It doesn't. My lady, have you...
No, I was double checking the review decision
Thank
to
you.
make sure that I hadn't missed anything in it. My lord's made the point.
My lady, yes. Insofar as the time element of the allocation policy is concerned, it's my submission that Broderick and Bromley, taken together with Alid Kiet, is really a nail in that submission. Because you were made the lead judgment, my lord, I probably only really need to take you to the head
I'm
note.
sure that my colleagues have not read this judgment. I mean, it may be that the head note will do, I don't know.
So if I take you to paragraph 37, these are the submissions on behalf of Miss Broderick. For his part, Mr. Fitzpatrick, who appeared for Miss Broderick with Sophie Casely, did not suggest that any more suitable accommodation was available to be offered on the 19th of December 2017 itself. He said, however, that the judge had been right to consider that in his case there was temporal leeway. What the council ought to have done was put Miss Broderick in the mix for a few days, say up to 5, after offering her 168 Richmond Road. That followed from the duty recognised in the Zolomezo to try to place a household, if not in district, then at least as close as possible to the district where they were previously living. In looking at the position simply on the date of the offer, this 19th of December, the council had not adopted a fair approach. And that argument was rejected as, in effect, not being what the Act says and placing a unnecessarily high administrative burden on the local authority. Paragraph 43 of your Lord's judgment, my Lord. Turning to the first question, whether the accommodation offered is suitable, that, it seems to me, falls to be answered by reference to the circumstances at a specific point. While the second and third questions may require examinations of change over time, suitability is determined at a particular time, as at a particular time. Where an applicant has accepted an offer and asked for a review, the focus will be on the position when the review decision is made. That, however, will not be so where an applicant has refused an offer. So the analysis is on the date of refusal. In relation to Mr. Fitzpatrick's argument that Miss Broderick should have been left in the mix for a few days, that arose really out of evidence that the London Borough of Bromley had provided as to the available accommodations on days either side of the day on which the offer was made. In paragraph 44, you say, if the pattern repeated, this is at E, my lords, my lady, if the pattern repeated itself over the next 3 days, by day 4 there would be 16 applicants and 16 properties. If, though at least 4 of the latter applicants had stronger claims to be close to the district than the first 4, it would seem that the authority still should not offer anything to the first 4, lest that prejudiced the applicants with greater needs. If after all, the authority gave the day 1 applicants the best of the properties that had become available by day 4, a more deserving candidate would have cause to complain if the properties appearing in the following days were further from the district and he was therefore offered something worse than day 1 applicants had received. A process such as Mr. Fitzpatrick advocated could thus be expected both to create problems for authorities and to result in properties standing empty to the disadvantage of the homeless. Whilst a particular applicant may obtain accommodation in or close to the district, applicants generally would suffer. Parliament is unlikely to have intended an interpretation giving rise to such consequences.
And back up at D, the 1996 Act does not, in terms, require suitability to be assessed in this way. That's the mix point. Moreover, any such approach would be impractical.
Yes. I won't take you to Alib yet because my learned friend has. I don't agree with him that Lord Justice Lewison's judgment relates only to in-borough offers, because it very clearly says in the relevant paragraph where the local authority is making a PRSO offer. It doesn't say an in-borough PRSO offer. There is no obligation to see if something better will turn up. Ground 1A is 2, the failure of the policy to apply out of borough duty, i.e. as close as possible. I think I've responded to that in relation to procurement, and I've explained that that isn't actually what the duty is. 1B, failure to consider failure to consider the availability of a closer 2-bed property. My lord, you spotted the difficulty with this argument is that Miss Zaman did not say she'd be willing to accept a 2-bedroom property until after the offer had been made. But in any event, if there is no temporal element to the application of the duty, there were no 2-bedroom accommodation available on the date on which the offer was made. Thirdly, Miss Zaman said that to the person, Miss Grant, who had been dealing with her personal housing policy, her PHP. Miss Butt, who was doing the review, was corresponding with Mr. Bernardini about the review, and Mr. Bernardini, in the representations on review, never raised that issue. So, in my submission, it isn't surprising that the review letter doesn't deal with that. And indeed, when Mr. Bernardini set out the representations that were being made, having received the minded to letter, he didn't say my client would have been willing to accept a two-bedroom property closer for the purposes of dealing with the affordability issue. Indeed, he doesn't nowhere in the representations dismiss Zaman raise affordability, which brings me conveniently to ground two. I just want to turn my back on you, my Lord. I know,
Yep.
I'm intended my learned junior may have something he wants. So my learned friend reminds me that, and he did the case at first instance, so he's more familiar with it than I am. There was an opportunity to cross-examine Miss Batt on her witness statement, and that was not taken. So in effect, her evidence goes in uncontested, and her reference to all locations means what it says it says. Means what it says it means. I just want to repeat one point. The absence of something doesn't mean that efforts weren't made to find the accommodation closer to Borough. Yeah, no, absolutely. Yeah, my learner junior reminds me, it's effectively innuendo. At what point is a applicant what point do they have to produce something that indicates that the local authority wasn't doing enough to find accommodation closer to the borough? And I've indicated what will result if details that my learned friend requests were given, then there'd be a further request, and it rather becomes like whack-a-mole. Each further request elicits a further request for more information. And my learned friend said in his submissions, well, the acquisition policy could have said why it's particularly difficult acquiring property in certain areas at certain times. Well, that would require revision of the acquisition policy on a daily basis, which effectively takes somebody away from trying to acquire property to redrafting the acquisition policy. Again, at some point, can the submission stand still so that we can deal with what is being submitted against us? Affordability. So I'm going to take you to 4 cases, my lord, my ladies. I'm going to take you to Ex parte Bayani, Balog, Paley, a case that me and my Lady Justice Asplin know well. Well, I probably know better than she does because she's doing these cases so often. And Samuels. I'm going to start with Bayani, which is at tab 7 in your bundle. So this is a case about what duty to make inquiry does a local authority have once the review has been initiated. And they are, I can take you to the head note for these purposes, 50 54.1. The duty to make inquiries is to make such inquiries as are necessary to satisfy the authority, as is the authority which have to be satisfied. If the court is to intervene by way of judicial review, it must be on the basis that the inquiries have not reached the required standard in the circumstances of the case. The appropriate test in a case of possible intentional homelessness is whether a reasonable authority, having made inquiries, and only inquiries which the authority in question in fact made, could have been satisfied that the applicant was homeless, intentionally homeless, etc. So, on inquiries in relation to affordability, in my submission, on the review, the test gets slightly more subtle. I apologise, I'll be with you in just a moment.
It's page 56 where we see the passage from the judgment.
Yeah, I wasn't going to read it.
Yes,
I just, excuse me, I was just, I just wanted to find the passage which, there is a subsequent passage in another case which says, now that there's a full-scale right of review, because Bayani was a case that was decided under the 85 Act, Cram for 14, I'm very grateful. So,
Tab 12,
tab 12, my lord, my lady.
paragraph 14.
And it's paragraph 14 on page 128. As I have shown, the review procedure gives the applicant or another person on his behalf the opportunity of making representations about the elements of the original decision that dissatisfy them. And of course, they may suggest that further inquiries ought to have been made on particular aspects of the case. Going down the page, given the full scale of the nature of the review, a court whose powers are limited to considering points of law should now be even more hesitant than the High Court was encouraged to be at the time of ex parte Bayani if the appellant's grounds of appeal relate to matter which the reviewing officer was never invited to consider and which was not an obvious matter he should have considered. Thank you very much. So, my lords, my lady, the next case is a case called Ballog and Birmingham City Council. It's at Divider 18. If you turn on to page 310, so paragraph 38 in the decision. This was a question about affordability of accommodation from which somebody had become homeless. And as my learned friends rightly said, that can be an element of intentional homelessness. So if you become homeless from somewhere that you could have afforded, it may be that you will be intentionally homeless. Paragraph 38. Mr. Ballog then approached Shelter, which gave him substantial advice and assistance in formulating his request for review in the manner I have described. The letter of the 6th of September 2012 set out the basis for that request at considerable length. It included details of the condition from which Mr. Ballog's daughter was suffering, etc., etc. It also asserted that Mr. Ballog did not appreciate that he was in arrears. That's reading 3 lines up from the bottom, my lord, my lady. Importantly, however, and despite the contents of the refusal letter, it did not suggest that the property was not affordable. The council was nevertheless, paragraph 39, alert to the issue of affordability, and the review officer specifically raised in his letter of the 9th of October in which he indicated he was minded to uphold the original decision. This letter included the 2 paragraphs set out at 13 above, which in due course were repeated in the review decision. So that you'll see this is a pattern of minded to letters are often review decision letters are often have a lot of repetition from the minded to letter. Excuse me. Once again, however, it did not elicit from Mr. Balog any suggestion that he disagreed or that the property was not affordable for any other reason. Moreover, by the letter of the 12th of October 2012, Shelter informed the council that it was no longer assisting Mr. Balog. So he didn't have further assistance on his response to the minded to letter. Paragraph 47, my lords, my lady. What was being suggested in this appeal was that the reviewing officer had not had regard to paragraph 1740 of the Code of Guidance that was then in force, which was the 2006 Code of Guidance. Paragraph 17.40 in that Code of Guidance repeated the 1996 order, Article 2. So that's the one about considering all income, all expenditure, all income, housing-related expenditure, and then reasonable living costs. The critical question for this court is whether this particular aspect of the reasoning of the review officer betrays a failure to have regard to paragraph 17.40 of the 2006 guidance. I have come to the conclusion it does not, for all of the following reasons. First, the issue of affordability is one which the review officer took for himself. He identified the failure of the original decision to consider whether Mr. Balog could afford to remain in the property. Secondly, in reaching this decision, the review officer plainly had regard to the statutory guidance, at least in general terms. Thirdly, it's true that no express reference is made to paragraph 17.40. However, I do not consider that this is at all surprising, bearing in mind that affordability was not a matter which had ever been raised by Mr. Balog or on his behalf. In my judgment, review officers are not obliged to identify each and every paragraph of the guidance which bears upon the decision they have to make. That would be to impose upon them a wholly unreasonable, unnecessary burden. I do not therefore accept that the absence of any express reference to this paragraph, the review officer failed to have regard to the guidance it contains. Fourthly, it's accepted that the review officer considered those matters which he was required to do so by the 1996 order to take into account. And we can see there that the decision set out income and expenditure The next judgment in the in the sequence of decisions is the decision of Samuels, a decision of the Supreme Court. My lords, my lady, at divider 23. If I ask you to turn to page 423 and paragraph 14 of the combined judgment of the court, you'll see there is set out a passage from the review decision letter. In this case, sorry, I apologise. This is not. Sorry, this was in the. This is in the review decision. In this case, the Child Poverty Action Group, paragraph 11, had put affordability in dispute. So you'll see how that was responded to at paragraph 14. It is now asserted that contrary to the provided figure of £150 for housekeeping, the actual figure is £750 per month, or £173 per week. This figure seems to me to be excessive, etc., etc. Down at the bottom of the, 3 lines up from that first paragraph, the part of the decision that impugned the review decision was, I cannot accept that there was not sufficient flexibility in your overall household income of in excess of £311 per week to meet a weekly shortfall of £34. So in effect, the benefits position was that there was a shortfall in housing benefit of £34 per week, an income of in excess of £311 per week, and it was said, well, you can rob Peter to pay Paul. The problem was that no analysis had been carried out of whether the £311 was sufficient to meet the household's expenses. So if you move on, my lord, my lady, to paragraph 32, page 428, under the heading Discussion, one of the issues in Samuel's was which benefits should be included in the analysis of income. And the Supreme Court's decision was, even though child benefit wasn't at that time referred to in the Code of Guidance, child benefit should also be included in the assessment of somebody's income. So it was all benefits. Paragraph 36, my lord, my lady, you'll see the basis of the decision. It's probably easiest if we start about 7 lines up from the bottom of paragraph 35, which is on page 429, 1 line down from the top. The guidance makes clear, as one would expect, that amounts will vary according to the circumstances and composition of the applicant's household. Further, to be noted that immediately after the reference to the household, there is reference to a current tariff in respect of such benefits, plural, which suggests that the tariff may be looked at in respect of benefits other than income support and at least a good starting point for assessing reasonable living expenses. 36. That is not how the review officer dealt with Miss Samuel's case. He asked whether there was a sufficient flexibility to enable her to cope with the shortfall of £151.49, that must be a per calendar month figure, between her rent and her housing benefit. However, the question was not whether faced with that shortfall she should somehow manage her finance to bridge the gap, but what were her reasonable living expenses other than rent, that being determined having regard to both her needs and those of her children, including the promotion of their welfare. The amount shown in the schedule provided by her solicitors was £1,234.99, was well within the amount regarded as appropriate by way of welfare benefits. In the absence of any other source of objective guidance on this issue, it is difficult to see what standard that level of expenses could be regarded as other than reasonable. So in effect, if you'd carried out a proper analysis, there wasn't sufficient flexibility, but you hadn't even carried out an analysis. The last case to deal with in relation to affordability is Paley and the London Borough of Waltham Forest, and that's at divider 28. If I could ask you to move on to paragraph 46, my lords, my lady. The CAB housing caseworker, having discussed the situation with Miss Paley, wrote to the local authority to provide submissions in support of the requested review. The grounds of challenge related to both location and affordability. Paragraph 47. So far as affordability was concerned, the submission highlighted that the rent was £144.04 per week, but that because of the benefit cap, Miss Bailey's housing benefit would be reduced from £144 to £97.42 a week, leaving her to make up the shortfall of £48.10 from her other benefits. At that stage, in the form of income support, child benefit, and tax credit. So before universal credit applied to Miss Paley. Disclosure of the housing file to Miss Paley and the CAB showed that in January 2020, by which time Miss Paley's state benefits were paid in the form of universal credit, the local authority had revisited the figures which had been previously provided by Miss Paley in July 2019 on her accommodation needs form. The schedule completed by a private sector officer and upon which it based its assessment as to affordability of the Stoke property was as follows. And you'll see there that that was the affordability assessment that was carried out in relation to Miss Paley. She had, in her previous accommodation needs form affordability assessment, had debts. She was repaying debts, it was said, at the rate of £50 per week. And she had a sum for public transport, both of which did not appear in the council's assessment of whether or not the offered property was affordable. And there was no explanation anywhere, or no reasonable explanation, why £50 debts were the repayment of debts at the rate of £50 per week were removed from the schedule, or no allowance was made for public transport.
So it was fairly marginal in the first place, as I understand it. If you've got 395 compared to 384,
Yes.
and then these other items haven't been taken into account.
So in Paley, the important things are these, in my submission. Affordability was raised on her behalf in the review. And the affordability assessment removed items that Miss Paley had said, of expense that Miss Paley said she had had, and provided no explanation for the removal of those items. So paragraph 84 of the judgment. In my judgment, the local authority failed to prepare a budget by reference to the needs of this particular applicant and failed to pay due regard to the 1996 order and the 2018 code. Far from there being sufficient flexibility in the budget to allow, for example, routine but frugal use of public transport and the occasional visit to her family, the affordability budget provided by the local authority was inevitably going to plunge Miss Paley even further into debt and as a consequence put her and her children at risk once again of being rendered homeless. And then at paragraph 85, the last sentence, as however the CAB said in their response to the review, just because a property is less unaffordable than a property in London, that does not mean it is affordable. So in this case, in the supplemental bundle, at page 172, so the pre-penultimate page. We have an income and expenditure form produced on behalf of for Miss Zaman on the basis of figures provided by her. The other income at the bottom, I'm told, is council tax benefit. So you'll see that council tax is in there at £16.75.
Sorry, I just understand that.
On the left-hand column, my lord, of figures under the heading weekly, you'll see there's a very bottom entry before the total is £11.70.
Yes.
That's council tax benefit. So the full council tax is put in as an expenditure on the column opposite, on the next column along. There was at one stage, I think...
Sorry,
apologies.
I just understand. So there's housing benefit, there's universal credit, then it says CHB.
Child benefit.
Oh, I see, yes. Yeah.
At one stage, I think it was being suggested that these figures didn't relate to the benefits to which Miss Zaman would be entitled in Stoke. That's simply wrong. They are the benefits to which she was entitled to in Stoke, because there's a different cap as between London and out of London.
And you said the other income 1170, that was?
Council tax benefit.
Aha.
So no discounts were made or adjustments to the figures that were provided by Miss Zaman, as they had been in Paley.
As I understood the point being made, it relates to public transport, because what is being assessed here is the position of Miss Zaman living in Stoke on Trent, whereas the public transport figure there of £21 relates to her living in Waltham.
It does.
Thank you.
The minded to this document was provided to Miss Zaman's very experienced housing lawyer representing her, Mr. Bernardi, before he wrote the first representations on the review. The minded to letter expressly says, we recognise that you will have, or you may want to travel to London to maintain your things. At no point in the representations, before the minded to letter or after the minded to letter, is the issue of affordability raised at all. And you'll see the first grounds of appeal drafted by Mr. Bernardini, the original grounds, don't raise the issue of affordability. I accept it would have been preferable if a sum was put in for occasional travel to London. But there is £130 surplus per week on the affordability. And in my submission, in the absence of representations on the review, that the property was unaffordable because the recognised need to travel to London on an occasional basis was not accounted for. In my submission, it does not impugn this decision. That specific provision was not made for travelling to and from London, particularly in the circumstances where there's a surplus of £130 per week. My lord, my lady, I am just about on my schedule. I've given myself till noon, and I discussed that with Mr. Capsavada. So I hope, if you don't mind, if I just use the last 10 minutes to show you how this case has evolved. Sorry. There was another case that I wanted to refer you to, but I'll refer you to the reference in the skeleton argument, and it's the BAT-T. Which is at divider 30, I think. Yes. And it's the Royal London Borough of Kingston upon Thames. It's referred to in the skeleton argument. At paragraphs 45 and 46. The argument in that case was whether or not, or one of the arguments in that case was whether or not regard should be had in assessing affordability to uncapped benefits entitlement or to capped benefits entitlement. It was a submission on behalf of the Royal London Borough of Kingston upon Thames that regard should be had to the capped amounts, because those were the sums that the applicant was actually entitled to. They weren't entitled to the uncapped amounts. Paragraph 46. Sorry, it's paragraph 62. It's paragraph 46 in our skeleton argument. I apologise, my lady. That's on page 619. I think it would be unreal to suppose that the Secretary of State, as author of the 2018 Code, intended to have the effect alleged on behalf of the claimant. That would mean that the Secretary of State, having promoted legislation to cap the amount of benefit available to large families, then promulgated a code identifying a higher uncapped amounts, which no claimant would ever in fact receive, as a guide to the sums that those families would reasonably require to obtain the basic necessities of life. So in effect, the amounts payable by way of capped benefits can be assumed to be sufficient where the housing element doesn't exceed the local housing allowance, in my submission. To me, now of course there are exceptional, there may very well be exceptional cases, and I accept that. But no exceptionality was being raised by Miss Zaman in this case. The offer letter which is in the core bundle,
Are you moving on to the evolution of the case?
we are.
Yep.
Paragraph, page 194 in the core bundle, paragraph 4, doesn't refer to the relevant part of the Code of Guidance, but the Code of Guidance that I've submitted just repeats the 1996 order in this respect. I am satisfied that the accommodation is affordable, having fully considered the cost of the rent and any other expenditure relating to the property compared to the income available to you. And based on the information provided on the 21st of July 2021. There was something else I do have to deal with. I apologise, and it may be that it takes me out of dealing with the evolution of the case, but you can see the number of opportunities the appellant has had to formulate her grounds and how they've shifted with time. In this, one of the issues that was taken in relation to the assessment of needs and the allocation of Miss Zaman to a zone was the form that was filled in, which is in reverse numerical order, unfortunately, at pages 33 to 42 of the supplemental bundle. And it was suggested that because no detail had been provided in relation to Zone A and Zone B, that therefore there hadn't been a consideration of those zones. When one remembers that the allocation scheme says, if you are somebody who could be housed in Zone C, but if accommodation is available in Zone B or Zone A, it will be allocated to you. In my submission, that form makes sense. Because what it is saying is, in effect, Miss Zaman is somebody who can be housed in Zone C. She isn't one of the people within the categories of person who has a higher priority under the allocation scheme. And indeed, it's never been suggested that she is. So the point, applying its own allocation policy, what the local authority had to decide was, are you somebody who can be housed in Zone C? Miss Zaman was somebody who could be housed in Zone C, but if on the day on which the allocation had been made to her, somewhere in Zone A or Zone B had been available and otherwise suitable due to affordability, that accommodation would have been offered to her. I was going to, rather than take you through the evolution of the case, I am going to submit that this is one of those cases where, in effect, a semantic dissection has taken place. We've had 37 pages of written material. My learned friend was on his feet for 3 hours, 45 minutes yesterday. His learned junior was presumably on her feet for hours in front of the county court. And there is going to be a reply. There has been you have been taken meticulously to evidence, and in my submission, out of the right sequence in response to questions that were not being posed at that time, to say they don't answer a question that is now posed. In my submission, this is a case in which the court should be very careful about accepting grounds that, in my submission, are based on supposition that a wrongly expressed duty hasn't been complied with. And I'll just remind you this, the duty is not, so far as reasonably practicable, to find somewhere as close to the borough as possible. It's to try to. And it's to try to for the purposes of maintaining the links. Once the links are broken, as they had to be in this case because Zone B was never going to be affordable for Miss Zaman, once the links are broken, the duty is to find something suitable in accordance with the allocation scheme. Because this was not rendered unsuitable if there was anything closer. Because of that amendment to the Code of Guidance. My lord, my lady, my lord, my ladies, those are submissions on behalf of the respondent.
Thank you very much, Mr. Grundy. Mr. Calzavara.
starting conventionally with ground 1, what is not in issue? There's no suggestion that the property is unsuitable. And that is true whether by reason of its out of area location, which the judge said in the core bundle at page 81, at paragraph 25.2, was 35 miles away. Nor is it said that it was unsuitable by reason of having 3 bedrooms, and more generally is it said it is unsuitable for any reason. This is a pure question of procedure, not of substance. Unlike the Zaman appeal, there is also no reasonable time challenge, no procurement challenge, and no zoning challenge. There's also, properly understood, no challenge to the reasons that it was not reasonably practical to accommodate in borough. Properly understood, the only reasons challenge relates to suitability. As I understand the appellant's case, ground 1 is made up of 2 issues. The first is, given that suitable accommodation was available in borough at the time of offer, did the authority fail to comply with its duty to secure in-borough accommodation so far as reasonably practicable? And the second is, did the authority give insufficient reasons as to why accommodation it did not offer was unsuitable? In outline, my 4 submissions in response to ground 1 are as follows. First, nothing approaching this argument was advanced on review, and it should not be entertained on appeal. Second, the ground is fatally based on an assumption that the appellant cannot prove. I don't know whether I said 3rd or 3, but 3, the duty to secure suitable accommodation trumps the duty to secure in-borough accommodation. And 4, there is no requirement to give reasons that accommodation that is not offered is unsuitable. Taking those in turn, the starting point is the well-known dicta in Cramp. Mr. Grundy's taken you to it, I won't. You'll note it's tab 12, paragraph 14, 1-4. It provides that the court should be slow to quash a review decision because a reviewer did not address something that the applicant did not invite him to address. I do, though, want to turn up Broderick, which Mr. Grundy has also taken you to this morning. It's not in the authorities bundle, it's one of the additional authorities. The passages in which I'm interested are at 48 and 49 of my Lord's judgment. There were 3 questions my Lord identifies at paragraph 38, and then 48, my Lord says, it's fair to say that the review decision did not address the second of the three questions I identified earlier. It did not need to do so, however. And then down at E, no argument was developed to the effect that the council had not been entitled to decide to make an offer on the day that it did so. And then at paragraph 49, neither was it necessary for the review decision to address the possibility of the property's suitability being revisited after the offer. It was not suggested to the reviewer that there had been a relevant change of circumstances. That is an example of the application, if I may say, of the Crown principle. How does that principle apply to the facts of this case? During the course of her homeless application, the applicant was accommodated with her, at that time, only daughter in a single room. After it was concluded that the main housing duty was owed, she and her by then two daughters were given a two-bed. After she produced the necessary evidence relating to by then having three daughters, she was given a three-bed. And then, still having three daughters, the property that the offer which this appeal relates to was also of three-bed accommodation. Before the offer, she said nothing about preferring smaller accommodation. She made two sets of representations following the offer and a further set on review. Mr. Hodgson took you to these, but there are a couple of points I want to highlight in passing, promising to take this quickly. Supplementary bundle, page 33. At the bottom of that page, we have the email dated 13th of August. Over the page 34, why is the property not suitable for me? First reason relates to the third daughter being under surveillance, so that's a not now reason. The second reason is vulnerability at the moment, not fit for the stress of relocation, again a not now reason. The third is I'm unable to sustain my children's needs fully at the moment. I've had help from my friends and family, this support will be cut off. That would be worse because I'm not driving at the moment. And the fourth is the school question, which we'll come on to. That page, bottom of page, no, starting on page 36, you have the second set of representations. Same day, first paragraph. Ms. Uduezue explicitly refers to the size of the property, but says nothing further. Second paragraph is a not now reason relating to the caesarean. Third paragraph is a not now reason relating to the COVID-19 pandemic. Fourth paragraph is the support. Fifth paragraph is the school. And then the representations made on review start at page 38. It's not necessary to look at anything on page 38. The substantive submissions start over the page on 39. The first is a repetition of the not now caesarean. The second is a repetition of support. The third is a repetition of school. And the last is irrelevant. Those submissions rightly delineated what it was that the reviewer was required to consider. Suitability is, of course, a matter for the authority, but the appellant said nothing to suggest that she considered that a two-bed would be suitable. That's particularly stark in light of her now saying that any challenge to the suitability of property on the basis of the fact that it was a two-bed property would inevitably have been without merit. That's a point made in the grounds of appeal, the skeleton argument, and by Mr. Hodgson on his feet yesterday. And with respect, in each instance, the appellant over-eggs the pudding. She said nothing, unlike Miss Zaman, for example, about preferring smaller in-borough accommodation to larger out-of-area accommodation. Had she done so, the reviewer might have been expected to consider the suitability of any available two beds. But it would, with respect, be wrong to quash the review decision because it does not relate to something which the reviewer was not invited to consider. Mr. Burton yesterday suggested in answer to questions that the authority was obliged to ask an applicant whether she wants smaller in-borough accommodation. But he made that submission specifically by reference to two factors that do not arise in the Uduezue appeal, namely affordability and the specific content of Waltham's Forest's policy. Just finally on the cramp point, although Mr. Burton and Mr. Grundy did, Mr. Hodgson did not take you at all, nor does he in his skeleton argument, to Abdikadir, which is at tab 31 of the authority guide. I'd say it's three passages you've already seen. I'll do so briefly. So it's tab 31, first relevant passage is paragraph 53. Lord Justice Lewison there says that because there is a duty, paragraph 53. Because there is a duty so far as reasonably practicable to make an in-borough offer, the authority must consider it, even if the applicant does not raise a red flag. And then at paragraph 57, applying that to the facts of Abdikadir, the authority hadn't considered private sector accommodation, and without doing so, it could not show that it had not been reasonably practicable to accommodate in borough. But that is not this case. Here it's not said that the authority failed to consider whether there was available in-borough accommodation. Here it's said that it was wrongly concluded that none of it was suitable. And while we're on Abdikadir, in order not to come back to it on ground 2, I just invite you to take a note that paragraph 51, Mr. Burton took you to it, gives a detailed summary of the principles relating to the carrying out of inquiries. My second submission on ground 1 is that the appellant cannot hope to achieve anything by it in any event. The assertion underlying the ground, the unrecognised assertion underlying the ground, is that the authority could not discharge its duty by offering out-of-area accommodation because the existence of suitable in-borough accommodation meant that it would have been reasonably practicable to accommodate her in borough. I don't need to take you to it, because Mr. Burton did, but that proposition is most clearly stated in Saleh at tab 24, at paragraphs 24 and 26. That's Saleh, tab 24, paragraphs 24 and 26. The appellant's premise is correct. Had there been suitable in-borough accommodation, it would have been more difficult, at least, to show that it was not reasonably practicable to accommodate her in borough. But with respect, she begs the question by asserting that there was suitable in-borough accommodation. The review decision is in the core bundle at page 119. Headline submission. The authority concluded that only a 3-bed would be suitable, and specifically that 2 beds and 4 beds would not be suitable. Although it's right to point out that Mr. Hodgson doesn't make his case on the basis of 4 beds. A whistle-stop tour, paragraph 29. This is who you live with. On that basis, it was concluded a 3-bed would be suitable. Paragraph 30, second sentence. In these circumstances, a property of that size was appropriate and met your housing needs. Paragraph 36. The property is a 3-bedroom house which is suitable for your household composition. Paragraph 43. Most clearly, in my view, property will be suitable for you in terms of size if it has 3 bedrooms. That is what you were offered. The last sentence. You have not raised any suitability concern with regards to the size of the accommodation. I am satisfied that the accommodation is considered a suitable size for your household. Paragraph 44. I'm satisfied the property is large enough for your needs. 55. As I've set out above, this is the 3rd line. As I've set out above, the property was large enough for your needs, with reasonable room space and size. 57, and I think these are the only 2 passages that Mr. Hodgson took you to so far. The council records show what was available on the date. What do we take from that? No in-borough 3 beds. That's what paragraph 57 tells us. If you need that more clearly, supplementary bundle, page 43. Then paragraph 58, 2 and 4 beds were not deemed suitable for your housing needs, and you were offered the only available 3 beds. The only way for the appellant to overcome those suitability conclusions would be to mount an irrationality challenge. But she does not do so. Instead, she boldly asserts 2 beds would have been suitable. But she is not the arbiter of suitability, and with respect, neither is this court. She simply cannot ask your Lord and Ladyships to decide that any 2-bed was suitable. And for that proposition, we need to look at Ali, tab 10. We're going to, I'm afraid, have to come back to Ali in round 4. It's on a completely different point.
Sorry, tab
10. For our purposes, relevant facts, paragraph 2. accepted the offer, moved in, sought a suitability review. Paragraph 14 is a quote from the recorder's decision where he not quite rhetorically asks whether he was entitled to make a decision as to suitability or whether that question was reserved to the authority. The easiest place to see that is second cited paragraph. Line starts, whether I am forced to say that the respondent, not I, must make the decision as to the suitability of the accommodation and must make a decision which is fully informed. At paragraph 15 in the citation, he sets out his view, reading from the top of his citation. What has been provided, in my view, if one uses the living room as a bedroom, is indeed just that, a 5-bedroom property, which, as I've already set out in my judgment, would provide for the family in all the ways that have been urged upon me as being the requirements of the family. At paragraph 17, the counsel on behalf of the appellants submits that it's clear that the recorder fell into error in 2 respects, and we're interested in the first. It would appear as though he was indeed taking it upon himself to make the decision as to whether or not the accommodation was suitable. And at paragraph 18, this court deprecates that self-direction. It seems to me that the arguments of Mr. Reaver on behalf of the appellants are correct. At the end of the substantive judgment is the passage to which I referred. It would appear as though the judge did consider that he had to make an assessment as to the suitability of the property in light of the conclusions of fact to which he had come. Applying that to this case, the appellant cannot hope to show that there was suitable in-borough accommodation. So she has no hope of showing that the existence of such accommodation meant that it was reasonably practicable to accommodate her in borough. I don't need to take you to it, but when your Lord and Ladyships are considering the appellant's arguments about overcrowding, and in particular about Haruki, which for your interest is in tab 14, I'd ask you to note row, which is in tab 33, and paragraphs 27 and 36. My third submission on ground 1, just look at the time, ground 1 is the hardest and the longest. Ground 4 will take roughly the same amount of time. Grounds 2 and 3 are very quick. My third submission on ground 1 relates to the nature of the relevant duties. The duty to secure suitable accommodation is absolute. The duty to secure in-borough accommodation is lesser, although reasonable practicability imputes more than reasonable. That is to say that the in-borough duty must give way to the suitability duty. I don't need to take you to it, but that seems to be what Mr. Justice Elias was saying in Calgin, tab 13, paragraph 31, which for clarity is not a point on which Calgin was doubted in Zanamesso. There is nothing objectionable, and indeed Mr. Hodgson hasn't suggested that there might be anything objectionable, with the 3-stage decision-making process adopted by the authority in this case. 1. Start by determining what type of accommodation would be suitable. And that might mean narrowing the search to properties of a particular size, or on a particular story, or with particular adaptations. 2. Search on any particular day for any accommodation of that type in borough. And 3. If there is no such accommodation, search out of area. My fourth submission on ground 1 relates to the reasons challenge. The appellant's complaint is that the authority did not give reasons for concluding that accommodation it did not offer was unsuitable. There is no obligation to do so, whether statutory or otherwise, for the reasons particularly set out at paragraph 40 of my skeleton argument. The distinction that the appellant does not grasp is that this is a different point to the positive duty referred to in Abdikadir to consider reasonable practicability. What is the obligation? I want to open up Zalamesso again to look at paragraphs to which Mr. Burton took you. Tab 20. There are only three I want to look at, which is why I permit myself the luxury of going back to the authority you've already seen. Paragraph 4, at C, rejection of out-of-area accommodation. Relevant fact. Paragraph 8, the reasons given for not providing in-borough accommodation are set out. You were taken to this already, I don't need to dwell on it. The relevant finding is at 36C. Between C and D, review decisions based on the premise that, because of the general shortage of available housing in borough, the authority would offer accommodation anywhere else unless the applicant could show it was necessary to remain in Westminster. No indication of accommodation available in Westminster and why that had not been offered. No indication of accommodation available nearer to Westminster, Greater London, why that had not been offered. No indication the reviewing officer recognised that it wasn't reasonably practical to offer accommodation in Westminster. There was an obligation to offer it as close as possible. This is not that case. The authority does not rely on the general shortage of housing per se. It has explained what was available in borough and out of area, including what was available closer to where the appellant was previously living. And even had there been an obligation to give reasons as the appellant alleges, we've seen the passages by which the authority makes a clear and reasoned decision. Nothing smaller than a 3-bed would have been suitable. I don't need to take you to them, but I'd ask you, when reflecting, to look at Libkiet, tab 21, paragraphs 82 to 85. You haven't been taken to those paragraphs. On the duty to give reasons in this context. El-Kundi, which I'm obliged to say is not in the bundle for this, although I know no one else has taken to it. Tab 29, paragraph 47, for the proposition that it's not necessary to have an Zalamesso policy. Again, I should say Mr. Hodgson doesn't raise a point about that, and it should in any event be clear from the Zalamesso tab 20, paragraph 42. That's ground 1. Ground 2 is an inquiries ground. To succeed, the appellant must show that the authority failed to make inquiries that no reasonable authority, properly directed, could fail to make. Irrationality. There's a helpful summary in Cramp. I didn't take you to it. Tab 12, paragraphs 57 to 59. I make 3 observations before looking at the substance. First, as with ground 1, this is a pure question of procedure. not of substance. Second, Section 11 seems to be referred to merely because the complaints relate to the appellant's children. But this is an inquiries challenge, pure and simple. It's explicitly not said that the suitability of the property per se, whether by reason of its location or otherwise, even touched upon the children's best interests. It's merely said that the authority ought to have conducted some unspecified inquiries into matters that were surely within the appellant's own knowledge, in order to obtain some information that the appellant has still not revealed. And third, there is no suggestion that the conclusions to which the reviewer came were irrational, so that again, this is a pure inquiries challenge. Remembering that the appellant must show irrationality, why does an authority conduct inquiries? To fill gaps in information, so as to come to a conclusion on an issue. In this case, whether the property was suitable. In her representations, the appellant materially asserted the property was not suitable because of her daughter's exams and because of the impact on her daughter's relationships. Mr. Hodgson's skeleton argument also refers to the appellant's own support network, but he says, as an aside, in prefacing that. And in argument yesterday, he made it clear that the loss of that support network was relevant only insofar as it affected the daughter. So I'm not going to respond to it separately. It's all tied up in the same assertions. Each of those points was a matter within the appellant's own knowledge. She did not suggest that there were any special educational needs, or indeed health needs, nor that her daughter needed to be educated in Borough, nor at her existing school, nor by a particular teacher, nor with the assistance of a particular teaching assistant. Indeed, the whole substance is that she was soon to move schools in any event. And one might have thought that making an offer of property over the summer holidays is sure to limit any disruption she might suffer. 11th of August. Yesterday, we had the first suggestion as to of whom inquiries might be made. Mr. Hodgson now suggests that the authority might have made inquiries of the school. He did not explain how the appellant's existing school might be able to help with the fact that the daughter was about to take exams to go to a different school. Indeed, he has still made no attempt to explain what further inquiries might have revealed, nor how further inquiries might have impacted upon the relevant question, which is the property's suitability. The reviewer explicitly referred to and accepted the substance of the representations, particularly relating to the daughter. I want a flag, but I don't need to take you to, starting on page 119 of the core bundle, paragraphs 11, 25, 31 to 32, 37 and 52 to 53. having accepted the substance of the representation, it is, in my respectful submission, unsurprising that the reviewer considered that there were no gaps requiring to be filled by conducting any further inquiries. That the appellant does not like the conclusion to which he came is nothing to the point. Ground 3 is a technical challenge relating to PRSOs. Would it be helpful for the court to look at 1937AC?
I think we probably ought to.
It's page 9 of the authorities manual on tab 2. And we can, starting at the bottom of page 9, we can basically ignore, we'll read it once and not look back at it. The purposes of this section offer is a PRSO if. What I'm going to say is that 1937AC defines a PRSO by reference to various tick boxes. And save in one respect, it's uncontroversial that each of those boxes was ticked. The appellant's complaint is either that the offer was made by the authority or that the landlord making the offer was not identifiable. I emphasise, as will perhaps have been apparent, the last two syllables. 7ACA must be an offer of an assured short tenancy, an AST. It must be made by a private landlord. It must be made to the applicant. It must be in relation to accommodation which is available for her occupation. It must be made with the approval of the authority in pursuance of arrangements. The purpose must be to bring the duty to an end, the duty being 1932. It must be a fixed term tenancy, and explicitly, because of the parenthesis, a fixed term assured tenancy. It must have a period of at least 12 months. The only controversy is 1937ACA. Mr. Hodgson asks you to read into 1937ACA that the landlord must be he says identifiable, but even taking his case at identified, his other assertion that it must be made by the authority is common ground. There are three responses, each of which can be stated briefly.
Sorry, his
Yes.
other point that it must be made by the authority. He says his other point that it must be made by the landlord, doesn't he?
Excuse me, must not.
Yeah.
Insert the word must not be made by the authority.
Yeah.
Yes.
Must be made by the landlord.
Must be made by the landlord.
And that's common ground.
That's common ground. It must be made by the landlord. I accept that. It must be made by the landlord. The corollary is it must not be made by the authority.
Mm-hmm.
Yeah. My three responses, each of which brief. The first is that notwithstanding making three sets of representations, the appellant expressed no interest in the identity of the landlord at any time before bringing her appeal, which, as the judge said, Core Bundle 80, paragraph 20, would not have been complicated, nor would have required statutory interpretation. You have my submissions on cramp, which I say also apply here. What the judge said, which would have been easy enough to express without resort to the complexities of statutory interpretation.
And sorry, when you say cramp applies here, we're dealing at the moment with the identification point.
Yes.
Yes.
Yes. Only with the identification. Yes. Sorry, I put them together.
Yes.
That may not be terribly helpful. The second is that there is simply no support for the proposition that the landlord must be identified to the applicant. And I pause there to repeat that the fact that the landlord was not identified to the appellant does not mean that he was not identifiable, which is how she puts her case.
By whom?
Identifiable by whom?
Yes. It was obviously identifiable by
By
the local authority.
Yeah, by the local authority.
So far as it might matter, it's not suggested that the landlord was identifiable by the applicant.
Not suggested. And the third response is that the authority communicating the offer of an AST to an applicant does not mean that it has made the offer on its own behalf. What we're talking about is differentiating between a case in which the applicant has privity of contract with a private landlord and a case in which it has a subtenancy with the authority. Where the offer is of an AST, privity of contract must exist between the applicant and the private landlord because the authority simply cannot grant an AST. To the extent that Mr. Hodgson responds to that by saying, I didn't have a copy of the tenancy agreement in advance, the answer to that, I'm going to refer you to it as a side point, is HHJ, tab 26, paragraph 77. And that leads me finally to ground 4.
So, sorry.
Yes.
So you accept that the offer has to be made by a private landlord.
Yes.
You say here what was communicated is correctly to be understood as the communication by the local authority of an offer made by a landlord.
Yes.
And you framed that on the basis that, well, if there was going to be a PRSO, it would have to be with a private landlord. Do we get anything in the terms of the offer itself bearing on this, or is it more a matter of general principle?
Below, Mr. Bruce has suggested that there were words in either the offer letter or the discharge letter or the review decision letter that made it clear that the authority was itself making the offer. We are offering. That isn't advanced in this court, and with respect, it's nitpicking to a degree that this court has deprecated on so many occasions it's impossible to count. There is nothing in any of those letters that can help this court with the offer having been made by the landlord or by the authority. It can't have been made by the authority. It's simply impossible. I can discharge my duty under 1937 by making you an offer of accommodation. I can discharge my duty under 1935 by making you an offer. In each case, I might be the landlord, but I can't make an offer under 1937A of an AST in respect of which I'm a landlord.
So, to be clear, absent some wholly exceptional case where a local authority had misguidedly framed an offer letter in a way that left no doubt that it was proposing to make the impossible offer. If a local authority offers a PRSO, it is necessarily making the offer on behalf of the private landlord.
No, I got that. The caveat is that for it to be a PRSO, it has to have been done pursuant to arrangements with the private landlord, the purpose of which is to discharge the authority's duty. Mr. Hodgson says nothing at all about that, and therefore we assume that there was a relationship with the private landlord, the content of which was that an offer would be made in order to discharge the authority's duty. Strange world in which the London Borough of Bexley has an arrangement with a local authority, with a particular landlord to offer a particular property to discharge its particular duty, but in fact it's not offering the accommodation pursuant to those provisions. It's offering it on a whim of its own. That leads me finally to ground 4. My focus here, as your Lord and Ladyships would have seen, will be on the 4 reasons that permission to appeal should be refused. I note my Lord's remarks yesterday, before my Lord interrupts me on that, and I'll come to those in a moment. The first reason that permission to appeal should be refused is that ground 4 raises neither an important point of principle or practice, test A, nor is there any other compelling reason that permission to appeal should be granted, test B. My Lord indicated yesterday that as long as some part of the appeal suffices, this is how I understood it, my Lord will correct me if I'm wrong, the second appeal, sorry, let me start that sentence again. As long as some part of the appeal satisfies the second appeals test, it's not necessary that each of the grounds does.
I have to say, I think we must hear appeals all the time as second appeals, where not every ground would satisfy the second appeals test.
But on the other hand, my Lord, you will have seen and indeed will have granted permission in cases in which you grant permission on ground 1 because it raises an important point of principle or practice, or there's a compelling reason to do so, but refuse permission on ground 2.
Rightly or wrongly, if I refused permission on ground 2, it would be on the basis that it had no real prospect of success. It would not be on the basis that it didn't raise an important point of principle.
I'm grateful for the indication.
I may be told by the other members of the court that I'm wrong, but that's certainly the approach I take.
Especially if they are so intertwined that it makes sense that they're dealt with together.
Let me develop this point as I think I can. I'm afraid, having had only overnight and Mr. Hodgson neither raising this point nor indeed addressing what the relevant test is, I don't have the advantage of argument nor authorities that I might look at. I make 3 submissions.
Yes.
First, this court should not construe Rule 52.7 in that way. It should find that each of the grounds must satisfy that test. This court is obviously well aware of the content of 52.7. I'll read the relevant part just to remind. The Court of Appeal will not give permission unless it considers that the appeal would have. And I wonder whether my Lord's remarks might rely on the distinction between the word appeal and grounds. I want to start then with Tanfern, which is one of the 3 cases that were handed up this morning. Tanfern's a case that straddles the old rules and the new rules. The passages I'm interested in start at paragraph 41. Parliament's responsible for controlling expenditure in the administration of justice. It's only in an exceptional case that a second appeal may be sanctioned. Paragraph 42, major change to our appeal procedures. You can't pursue a second appeal merely because it's properly arguable or has real prospect of success. G, the new statutory provision is even tougher. The decision of the first appeal court is now to be given primacy unless the Court of Appeal itself considers the appeal to raise an important point of principle or practice, or there is some other compelling reason for it to hear this second appeal. 43, last 3 lines, last 5 lines. If they wish to pursue the matter further and to incur the often quite heavy costs involved in paying the court fee for preparing the appeal papers, the Court of Appeal may dismiss their application quite shortly, saying the appeal raises no important point of principle or practice. There is no other compelling reason for the court to hear the appeal. And paragraph 44. The reason for this significant change of appellate policy can be found in the 97 review of the business of the Court of Appeal. Reported over the previous decade, substantially increased the number of cases coming to the court. Authors believed if there had to be an appeal in a civil case, this should normally be the end of the matter. This principle reflects the need for certainty, reasonable expense, proportionality. Must be special circumstances. There's more than one level of appeal. Elsewhere in this report, judges of the quality of Lords Justices of Appeal were a scarce and valuable resource. Of course, Lord Justice Brooke meant Lords and Lady Justices of Appeal. And that it was important that they were used effectively and only on work which was important to them And finally, paragraph 45. In the 99 Act, Parliament not only accepted the report's analysis, also adopted even tougher measures, those recommended by the review, to ensure that second appeals will in future become a rarity. My respectful submission is that it would be strange if the intention was to limit the work that this court and judges of this statute in the judicial hierarchy should be bothered by. I mean no disrespect by that use of language. Only to then say that as long as one of the grounds passes the test, this court may in any event entertain any number of grounds that don't pass the test. Overnight, I'm afraid I was only able to find one example of this in practice, and that's particularly because the practice direction makes it clear that I can't cite authority. It doesn't make it clear that I'm allowed to cite that authority. That means it has to be a rolled up decision. And that rolled up decision is Haddock, which is the third of the three cases that were handed up this morning. The only paragraphs which I need to take you, I'll take you to 1 and 2, please. In paragraph 1, halfway through, Lord Justice Patten says, the appeal requires us to consider two issues. One relates to a particular clause of conveyance. The question is whether it falls to be construed as matter simply as a covenant, or rather as the creation of an easement. And the second relates to whether, as the courts below have held, it's possible to create such an easement by express grant. What does Lord Justice Patten do? Paragraph 2. My lady gave permission for a second appeal on ground 2 only. My lady Justice Asplin, on the basis that it raised a point of law of some general importance, but left the golf club, the appellant, to apply to the full court for permission to appeal on ground 1. What does Lord Justice Brooks say? Lord Justice Patten say? Although questions of construction of this kind do not ordinarily satisfy the test for a second appeal contained in 52.7.2, and I note he's not expressly referring only to test A or test B, he's saying the whole of the test. I am satisfied in this case the issue of construction is so obviously bound up with the ground of appeal, which permission has been granted, as to create a compelling reason for granting permission to appeal on that ground also. Lord Justice Patten does not say, I'm now applying the first appeals test. He says, I'm applying test B. That is the only example I have found of this happening.
Yeah.
Second submission, even if I'm wrong about that, and I emphasise, with respect and without meaning at all to sound facetious, it would be surprising if this court gave guidance, particularly in a case where the appellant has not raised or indeed engaged with the point, that as long as would-be appellants can find one ground that passes the test, they might try their luck with any number that obviously do not, requiring this court to wade through grounds that advocates don't consider pass the second appeals test. And third, even if I'm wrong about that, I presume, and particularly based on what my lord just said, that it's suggested that Rule 52.6 should effectively apply, in which case the decision whether to grant or refuse permission to appeal remains discretionary. And I invite your Lord and Ladyships to refuse permission in any event for the other reasons that will follow. It's about 6 minutes to 1. I can get started on test A and uphill.
I wonder whether, since time is... How long do you think you will need after lunch?
20 minutes.
Well, let's rise now. Shall we start again at 5 to 2, just to make sure we don't have time problems?
Court rise.